All right, welcome back, everybody. Thank you for tuning in to another edition of Meet the Expert. Hopefully you found some value in last month's edition when we talked to Joey Police of Blue Edge Networks, and I know it kind of freaked me out, but anyways, you don't have no idea what I'm talking about, but that's okay. We've got a new guest today. This is Taylor Stuckey. Taylor is with Stites & Harbison. He is an estate planning attorney here in Lexington. Many of you watching maybe have already interacted with Taylor. Many of you maybe have heard me talk about Taylor. So just a couple of housekeeping odds and ends right up front. We refer a lot of business to Taylor here. So if you're a client of ours and you're like, I need some guidance on the estate planning side, he's probably one of the few folks that we will recommend you to visit with. Also, just in personal disclosure, I have used Taylor for the last several years. Our family has had our estate planning documents and our trusts and so forth developed through Taylor. And the other tidbit, though, is no, we don't have any, side deal. I think that's even illegal. Isn't that illegal in the state of Kentucky?
It is,
you can't get compensated unless you're an attorney. So I am not an attorney, and I don't play one on TV. So, Taylor, welcome to the show, or whatever this is. Welcome.
Yeah, thanks for having me, Quint. It's always great to see you, and on camera for the first time, I think, with you.
And you do great. I've had him on the radio. Were you on Jack Patty at one point, or was that
we did Cruiser.
Cruiser. You were on Cruiser. That's when you broke out of your superstardom, and
that's
now
right.
You sign autographs. I mean, you had the paparazzi on the way in. The whole 9
now
yards.
people will recognize my face. Only before it was just my voice. So
that's true. So, well, Taylor, again, thanks for coming in. Really appreciate it. We're going to dive into some nooks and crannies. Many of you, this is not a riveting subject. Many of you are like, oh boy, here we go. But I'm so passionate about this, and I'll tell the folks at home why in a little bit. But give us a little bit of your background. Your history and why you're in this profession, how you got to do what you do, et cetera.
Yeah, so I actually grew up as the son of an estate planner. My dad is still an estate planning attorney in Florida. I really liked the relationships he was able to develop with his clients. It's a very personal subject. It's not like a lot of lawyers working for big corporations. You actually get to know people, and you get to help them with their personal problems and hopefully create solutions for them that make their lives a little bit easier. I got my undergraduate degree in accounting, went down that road for a while, 3 years as an auditor, pretty soul-crushing work, so decided to go back to law school. Still with estate planning in the back of my mind, thought I would go back and work with my dad in Florida, but met my wife when I was in law school. She's from Louisville and lives in Lexington, has for 20 years, so that's home, and I'm happy to be here, close to some relatives on my mom's side, and also close to Keeneland, which we were just discussing a minute ago, is something I really like to do in my.
And you just had a baby
time.
not too long ago, right?
Yep, I've got a 6-month-old and a 5-year-old, and they're both doing great.
Great, yeah, you're in the weeds.
Yeah,
5 years
that's
and
right.
6 months. Woo! And now you did your undergrad. You go to UVA?
I went to Notre Dame.
Notre Dame, that's right.
Notre Dame undergrad, law school at UK.
UK, yep. Excellent. Well, we're glad to have you in Lexington, and you're with Stites & Harbison here in town.
That's right. I've been with Stites & Harbison for almost 10 years now.
Oh, that's great. I did not know you were a second-generation estate planning attorney. That's you don't say that much.
No, I don't. And really, my dad, I wasn't sure exactly what he did. I think because, like you were saying, this isn't the most riveting subject. We didn't sit around the dinner table and talk about his estate planning, the things he was doing in estate planning. But we did talk a lot about his clients and his clients' families, because they really do become sort of like his own family members once he's been working with them for a while.
So I'm going to tell you why I'm so passionate about this, and why I always try to bring this up with folks and clients. Obviously, we're a holistic planning firm. We're looking at everything, not just what the markets are doing on a daily basis or who's in the White House, but we're talking about big picture stuff. And there's really 3 reasons that I'm so passionate about this, and one hits pretty close to home. But the first is, I have personally gone through a situation where folks have come to me, someone has passed unexpectedly, like young, and there were no documents in place at all. And you talk about a mess. And I think, you've kind of guided them and helped them through that, but what a mess to not be prepared for something like that. And there was young kids involved and so forth. So number one, my passion comes to the fact that if you're younger a young family or a younger person in general, and you think, I'll worry about that later. No, now is the time. Number two, and this hit really close to home when a very close, like, father figure passed away, a fairly sizable estate, and Taylor and I worked incredibly hard together to preserve this estate for the surviving spouse. And I saw it firsthand, the massive difference an estate planning attorney who cared and being involved, because there were 11th hour, like, I'm calling you on a Sunday going, hey man, I need to get these documents, understand them, et cetera, et cetera. So that's number two. Number three, as you know, because you did the documents, I have a special needs son. Maybe some of you know that, some of you don't. Our third child was born with some genetic disorders that will basically keep him in our home for the rest of his life. And so there needed in our family to be some special provisions carved out within our legal documents to not only make sure he was cared for, like who's going to take care of him, because I don't want the state to determine that, but also where do specific resources go for his benefit so that he doesn't lose government benefits such as his Social Security, not disability, but Social Security, disability income. So he will not lose those. So those are three reasons that I'm super passionate about this riveting field, if you will. So Taylor, I mean, give us the broad, if you were to meet with somebody and they say, oh, you're a estate planning attorney, well, what do you recommend for me? And I know it's a personalized situation. I get that. We say the same thing. But what should everybody be thinking about when it comes to their estate plan or their legal documents?
Sure. There's three documents that everyone really needs. You need a will. That's the document that's going to say what happens to your stuff after you pass away, who it goes to. Everybody needs a power of attorney. That's a document that allows somebody to make financial decisions for you, do financial actions on your behalf. It's especially useful if you become disabled and can't do those things for yourself. And then the third absolutely necessary document is a living will and healthcare surrogate designation. That does two things. One is it names somebody to make medical decisions for you if you can't make them for yourself. And the second thing it does is it gives expresses your wishes with respect to end of life care. So if you have an accident and you're hooked up to life support and being kept alive artificially, expressing your wishes so the person who has to make the decision whether to keep you alive on life support or to disconnect you knows what you would have wanted to have happen in that situation.
Now, I'm glad you went there. You went right to the ancillary documents. It was one of the questions that I had because I feel like a lot of people don't get a will because they don't have anything. And they're like, look, I don't have anything. They're young. They got a 401k. The 401k goes to the surviving spouse or maybe the contingent beneficiaries or the kids or what have you. And they're like, look, I don't have anything. Why would I get a will? But you nailed it. It's not just the direction of your stuff, whether you have stuff or not. It's very important, the power of attorney, who can make decisions. You become incapacitated. The bank account, you got to go find out what's in the bank account. How do we pay bills? How do we do this, et cetera? Who is doing that, right? And then, as you mentioned, the living will healthcare proxy, which I thought those were two separate documents. I guess they're not.
That we combine ours. You can have two separate documents. Yep.
Excellent. So living will, kept alive on machines or not. Healthcare proxy, so, he goes in, you're out of it, and nobody, who's going to make the decision whether we have this surgery or not, are extremely important documents to have, basically, for anybody. Now, when someone does this, how often do you see someone put something like this in place, and then, 15 years later, they're like, oh, my gosh, Bob? I don't even talk to Bob anymore, or Sally, she's not even alive. She can't make these decisions. How important it is to know what's in your documents and maybe be revising them over time.
Yeah, that's a great point. Just as a rule of thumb, we say every 5 years, take a look at what's in there, make sure you understand what's going on so you don't have that circumstance where you're like, wow, this person has been out of the picture for a long time and they serve a very important role if I were to die today or if I were to become disabled today. So that's kind of a rule of thumb. Any kind of significant life change, you want to review those and make sure they say what you want them to say. But just as a rule of thumb, every 5 years is probably a good one.
Now, I know the answer to this, at least from my own peace of mind, but I want to hear your answer. So why don't I just go on the internet, Google will, living will, healthcare proxy, fill in a couple blanks, and print it out and be done with it?
Yeah, I mean, you could do that, and honestly, that will work sometimes. The reason you want to use an attorney, there's several reasons. One is, LegalZoom is kind of like a one-size-fits-all deal. They're trying to serve a bunch of people. It has its place in the realm of legal services. But the thing about an attorney, especially a local attorney, we've seen some things. We see what doesn't work. Especially like in the state of Kentucky or the city of Lexington, we know what provisions a bank needs to see in a power of attorney for them to allow the person you've named to act on your behalf. A lot of that stuff is meant to be user-friendly. It's not always. It's very important in this area to kind of dot all your I's and cross your T's, make sure you've executed the documents correctly, because little mistakes can totally invalidate your documents. And the cost difference is not that much. I mean, the costs on LegalZoom and other sort of similar products have kind of crept up over the years. And what we're seeing is, for the types of plans that most people end up having, there's not a significant difference in the costs, and you get to work with an attorney who knows what they're doing and can listen to you and adapt the documents to your personal situation, rather than trying to fit you into a document that's already been drafted before the software even took down your information.
So even prior to Aaron, who was our child with some special needs, which created some unique planning, do you know why we used you instead of going on to LegalZoom and so forth? I mean, well, so first of all, and I know this is a weird question, but it'll circle back around. How old are you?
39.
39 years old, working at a firm that's been around for, 100 years or so. I mean, very long term, and a lot of gray hairs in your
certainly
area inside of Stites.
We trace our roots back to the great Abraham Lincoln.
Excellent. So, but the reality is, I'm 46. So guess what? You're going to be around probably as long or maybe longer than I am. I like that. I like that you're on my team, because I need a team too. Like Jewel is my financial team. If I were to get hit by the proverbial bus, I got Logan, right? 10 times smarter than me, 20 years younger. What an amazing, advisor to have. I've got you, who my wife knows exactly. She's got your number. I mean, she knows something happens to Quint, we're calling Taylor for the legal side of things. So I think it's critical to have someone who your other person or your family is contacting to make sure this stuff gets taken care of. Now, that's why I did. I mean, I just peace of mind of my teammate, my part of my overall team to care for my family and what we've set out ahead of time. Now, I want to transition a little bit, because I feel like lately, over the last couple of years, there are so many services pushing trusts. And I know that we have a trust, right? We have living trusts. And again, I've talked about why that is. It's primarily because of Aaron's situation and young kids. But what is your view on, I mean, first of all, am I right in that? Is there more people pushing trusts now than ever before? And at least since the credit was $675,000, which it was when I got into the business. But what is it needed for everybody? What's your view on that, et cetera?
Yeah, so I mean, a living trust is part of our standard plan, and we recommend them for most people. And the reason for that is most people have children. When you have a child, a trust allows you to leave them money, name somebody else to be the trustee of that money, to take care of that money until your child is old enough to manage it him or herself. And a living trust has the added benefit of it comes into existence while you're living. You can move assets into it in an attempt to avoid probate. That's one benefit. It helps the ease of it helps the transition after you pass away, to not have to go to court and have a court proceeding, and you can achieve that if you get all of your assets into your trust or arrange them in such a way that you avoid probate. But the big reason most people need trust is because they have children. If a minor inherits money, somebody who's under the age of 18, the process is very complicated and onerous. Whoever is going to be the person who's taking care of the child has to go to court, get appointed as the child's guardian. They have to file reports with the court, showing how many assets came into their hands as guardian for the child. And then every year they have to file a report with the court saying what they spent. Most times these guardianship accounts are it's called a restricted account, where the guardian has to have a court order to be able to use the funds in the account. Those accounts are set up to go directly to the child once they reach the age of 18, which, if you remember how you were at 18, I know how I was at 18. I was not ready to inherit all of my parents' wealth at that age. And we see that occasionally with people who don't have planning in place or have not done trust planning for their minor children. We shared some clients like that where the child reaches the age of 18, maybe they're still in high school, and all of a sudden they have a great deal of wealth. They've had you in their lives helping them, so they're actually more equipped than most 18-year-olds are to get that kind of wealth. But it's still not an ideal situation when somebody still has so many important decisions to make about their future, for them to all of a sudden have a bunch of money that they didn't necessarily earn. It's just found money.
So let me ask this then. What's the difference? Why would you not just write that in? I mean, instead of a living trust now, why not write that into a will that upon my passing, if my minor child is, or my child's below 18, this goes into trust for their benefit?
There's really two reasons. One is privacy. So all wills after you pass away get recorded in the public record. If you put terms of a trust inside of a will, they're public record. Everybody knows what you've done, how your money's been distributed after you pass away. If you have a living trust, you can have a fairly anonymous will that just says everything goes to my trust. The public is going to know that you left everything to your trust, but they're not going to know the dispositive terms of the trust, who you actually left the money to. Second is if the trust doesn't come into existence until after you pass away, you lose this option for funding it and avoiding probate. So the benefit of the living trust is that you can put stuff into it while you're alive, and once you put it in the trust, it avoids probate.
And over the years, I feel like people confuse that they don't really understand the term probate. So I think they almost think it's like a noun, it's like a person, place, or thing, but it's not. It's a verb. It's a process. Is that right? I mean, it's a court process of distribution of assets.
That's exactly right. So, and there is value in probate, especially if you have a contested estate. It gives a forum for everybody to come forward and stake their claim to the deceased person's assets. But that's also not what a lot of people want. Especially kind of in an orderly family where everybody gets along. They just want to move to the next phase. There's enough going on. They've lost a loved one. They want to be able to grieve. They don't want to be having to go to court and file a bunch of paperwork and file reports with the court. They want to be able to move to the next phase of their life as quickly as possible. It's important. Oftentimes, the main breadwinner in the family has been lost. It's important to have the assets, the inheritance available to the beneficiaries as quickly as possible. And when those assets are tied up in a probate proceeding, it just makes it a little more difficult.
Yeah, I can't stress that enough. Whenever we work with, and again, I'm not an attorney, I don't claim to be one, but when we work with folks and we look at everything and we try to determine the direction that they want to go if they're not here. Because certain assets can be titled with beneficiaries, right? I mean, yes, there's retirement assets that have beneficiaries, but you can add beneficiaries to investment accounts or to bank accounts, et cetera. But you're right in that if there's not a plan ahead of time, whether it's through legal documents with your set of advisors, if it's not discussed, then what ends up happening, I've seen it, is a person passes, the surviving spouse is obviously, just devastated. They take these legal documents, they call the attorney, like, here, handle this. Don't know where things are, have never combined, you know what I'm saying? Like, just lost. And then the time period, as you mentioned, it can take a very long time to get things settled. And so I can't stress enough, again, whether you already have a good attorney, you're working with somebody, you've never worked with any, get this area of your house in order. I cannot stress enough. It is so critical. And I'm a believer, again, whether it's me and Taylor or your own team that you've put together. I don't care. It's about having that team in place, communicating, everybody on the same page so that when you're not here, it goes the way you want it to go. All right, last question I have for you is give me 2 or 3 kind of pitfalls, like things people do or don't do that you've seen and you're like, oh, like in our business, obviously there's trying to time the market, right? We're in a difficult environment right now. Markets are down, the world is ending, and whatever. And everybody, inevitably I'll have somebody who's like, get me out. I'm done. I'm out. Every time I'm like, oh. Like, and the problem is, I'm going to get off my soapbox in a minute. The problem is that even if they're right, like they get it right, they nail it. Like, oh, I nailed it. They're not getting back in. I've seen it. They're not getting back in. I've seen people who got out in COVID lows, never got back in. Like, just never did. And so it's timing the market is futile. There's other things that I see. My buddy down the road, told me about App Harvest. What do you think? Can I buy some app? No, stop. Like, I'm just like, so what? I hope I didn't pour salt on any wounds of our listeners. That would not be good. I might have made some people mad. You didn't buy App Harvest, did you?
I did not.
Okay. So, what are 2 or 3 things that when you see it or hear it, you're like, in your industry?
Yeah, so I think a lot of times people will do their estate plan. It's great. We're thrilled. You came in. You did what Quint told you to do. You got all the documents, but then they don't update beneficiary designations, or they don't give all of the information to their attorney because they think that hey, this guy's billing me by the hour, and I don't want to spend more time with him than I have to. Which, by the way, we try to flat fee as much as possible.
I do like that. I forgot to mention that. Yeah.
So you don't feel like you're on the that the meter's running when you're talking to me, because we want the full picture. There's a lot of assets that pass other than by the documents that we create. So a good example of that is life insurance. So if you have life insurance, but you haven't named a beneficiary, those life insurance proceeds go through your estate, which exposes them to creditors potentially. Yeah, they'll end up in the trust if you've done a will, and it kicks it over into the trust. But you really want to update your beneficiary designations to name the trust, so it goes into the trust. Sometimes people will have beneficiaries that don't match up with the plan they've got. So they've got they're leaving everything to their kids, but they bought their life insurance before they had kids, and they've got their sister named on there. So now we've got an issue after they pass away. How do we get it and make sure that it goes to their kids? So that's one thing, is not updating beneficiary designations. Another thing is sometimes you'll see people try to change their documents on their own. So you'll have a will, and it'll say one thing, and the person will have lined that out and written something else in. That's a bad idea.
I didn't even know that was a thing.
Yeah. So you can actually partially revoke a will, but you cannot make changes to a will without actually re-executing the will.
Oh wow.
So don't ever try to change your
cut
documents.
Out somebody. No, don't like this kid anymore.
That's
out.
Exactly right. So these are situations where people have done all the right things. They've actually gotten documents in place, but they have made some kind of mistake to either invalidate them.
How about this one? And I see this a lot because I see advisors who don't follow through. So an advisor finds a person like you, great client, let's call it business owner or something like that, says, you need to go, you implement a living trust. So think of a living trust like a bucket. And typically, most people, each individual has one. So I have a living trust. My wife has a living trust. We each have our own living trust. That's fine. But then you need to actually retitle assets into the name of the living trust. So I have seen estates. Thankfully, I've not seen one where someone passed and this happened, but they're alive, and they come in and they say, and I ask them inevitably, estate planning doc, we each have living trusts. Here they are. And I look at them, I go, that's good. I said, none of your assets are in there, and then it's awkward. What are you talking about? We have a living trust. What do you? Yeah, well, see this bank account? You see this investment account? How it says your names? It doesn't say your living trust. And there was a breakdown of communication. Either the attorney or the advisor, or they just didn't get around to it, or the deed. Like a lot of people do this to pass their home, right, freely to their family without going through probate. But they don't update the deed. How long does that take?
Yeah, it doesn't take long, and there are reasons to not there are reasons to not fund. So, when you're young and
yes.
you've got a, kind of a situation that's ever changing, I tell those people, hey, avoiding probate, we look at that down the road when your situation settles down. Let's not even try to do that because it's such a moving target. But you want to make that decision with eyes open. You don't want to have not had it explained to you that, hey, this is why we're not funding your trust. It's important for people to, maybe not understand every word that's in a 20-page trust agreement, but at least understand directionally how everything goes, understand how it functions, and if avoiding probate is a goal we're trying to achieve, what have we done to do that? What is left to be done to do that?
So this is being released right before Thanksgiving. So first of all, happy Thanksgiving, everybody. But the reason I did it this time period is typically this is when everybody gets together with their families. These are things you need to talk about. People need to have this dialogue. You need to have, even though it's awkward sometimes, like pass the gravy and this is what's going to happen when I die. Like these are conversations you have to have with your family. Please do so this holiday season. Taylor, if someone's watching this, do they have to be local?
No.
To use you is what I'm getting at?
No, definitely not. We especially if you're working with Quint, I've helped people all over the U.S., all over the country.
And what happens is you are able to produce the documents, send them to them. They just need to get them notarized with witnesses.
Right. We give very specific instructions on how to get them executed. Yep.
So that's important. If you're watching this and you're somewhere in the U.S. and you are looking for a good estate planning attorney, again, no remuneration. I'm gonna make that very clear. The guy doesn't even buy me lunch. We're going to have to talk about that. But anyways.
The alligator arms.
When the check comes. But anyways. Feel free to reach out to Taylor. He's been great. Anybody we've sent his way. If you're interested in someone else too, we have a couple that we would refer to. But personally, I've used Taylor. Our family's used Taylor for many years now, and very well pleased. If somebody wants to get a hold of you, how do they do so? Other than contacting us, which we have your information, but how would they do that?
Yeah. So email tstuckey, TSTUCKEY at stites, STITES.com. That's my direct email address. I usually try to respond to that within 24 hours. 859-226-2289.
Nice.
That's my direct line. If I'm there, I'll answer.
Great.
If not, I'll call you back as soon as possible.
And we'll put all that in the notes below. So, Taylor, thanks so much for coming in. Really appreciate it. Your wisdom is amazing, and I know it's benefited our family and many, many of our clients. So thanks again for coming in.
Thanks so much for having me, Quint.
All right, everybody. Make it a great day.